my last murder trial that I had, the defendant gave a very lengthy statement, and we chose not to introduce this statement for the very reasons we're talking about right here. We knew in the statement he was interposing his defense, which in that case was self-defense and passion provocation. It was kind of a mixture. He kind of threw the kitchen sink in there. But by not introducing his statement, we felt we could still get a conviction. But what it essentially did was forced him to the witness stand. It is a really risky move when you've already got a statement that's been introduced because the prosecutors put it in, to then be taking the witness stand where you can now be cross-examined with that statement. How's he doing? I mean, right now he's doing fine. He's on direct examination, a little hedgy, seemed to be losing focus. The question should be like a dance, a choreographed dance, when it's your lawyer asking the questions. So the truth here is really going to be, how's he going to do on cross, especially now that the prosecution's in possession of a transcript, which in the hands of a capable prosecutor can be a deadly weapon. I was thinking when I was listening to this, and again, going back to that last trial that I had, one of the greatest things that ever happened to me in a courtroom was the defendant's demeanor on the witness stand. The cold words on a transcript are one thing, but when a person is actually testifying, the manner in which you're testifying, how they're coming across, their edginess, their eye rolls, their attitude. And we literally had a defendant took a stand that they had to clear the courtroom because he got violent in the middle of his cross-examination. So, of course, that's a prosecutor's dream in a situation like that. But, yeah, it could come off as snarky and nasty. And so you got to be very, very careful that the witness, the defendant doesn't come off that way because, like Maya Angelou said, right, it's not what you say, it's not what you do, it's how you make people feel in the end analysis. And his relationship and rapport with the jury is very important. And you know what? The bottom line here as a lawyer is you got to do what the defendant is telling you they want to do. If they want to take the stand, they take the stand. But we've seen many cases where we thought it would be a not guilty. The defendant took the stand and talked themselves into a conviction because the jury just detests them as people, in my opinion. While the PTSD would not go to the self-defense claim, it could go to a lesser offense of what we would call passion provocation. That is, it's the person wasn't able to form an intent because of their psychiatric condition, the stresses at the time of the moment. They weren't able to deliberate and fabricate to act purposefully or knowingly. I know it's really wonky, you know what I'm saying here. You got to be really careful when you're giving those defenses because they can be contradictory to one another, but maybe not so much in this case. And maybe they're thinking to themselves, well, if I can't get through on a self-defense, which is an outright acquittal, let me see whether or not the jury may choose between the higher murder offense to a lower offense of some sort of passion provocation. It could be strategic. I mean, it would seem to be because they're bringing it out. To me, it may also whiplash that the jury thinks the guy's got a hairpin trigger personality.